Mrs. Evelyn Carter sat alone at the defendant's table in her worn brown coat as Judge Harold Whitman cut her off with a condescending chuckle. He made jokes about people her age, threatened crushing fines, and dismissed her concerns while the courtroom laughed along. Everyone assumed they were watching just another elderly woman being put in her place. But there was one thing none of them knew about the quiet woman in the faded coat, one detail that would turn their world upside down and expose 15 years of hidden cruelty. Today, Mrs. Carter was going to show them all what happens when power forgets that justice is always watching. Just before we get back to it, I'd love to know where you're watching from today, and if you're enjoying these stories, make sure you're subscribed. The rain came down in sheets that Monday morning, turning the streets outside the county courthouse into rivers of gray water. Inside, fluorescent lights buzzed overhead, casting their harsh glow across a crowded courtroom that smelled of old wood, stale coffee, and the nervous sweat of people waiting for their cases to be called. Mrs. Evelyn Carter sat alone at the defendant's table, her hands folded neatly in her lap. She was in her late 70s, her silver hair pulled back into a modest bun. She wore a worn brown coat that had seen better days, the kind you might pick up at a thrift store or inherit from a relative who'd passed on. The fabric was clean but faded, with small pills forming along the sleeves. Around her, attorneys in sharp charcoal suits shuffled papers and spoke in hushed, confident tones. Court clerks whispered behind polished oak desks, their fingers flying across keyboards. Mrs. Carter looked completely out of place, like someone who'd wandered into the wrong building by mistake. The courtroom was packed that morning. Monday dockets always were. People sat shoulder to shoulder on wooden benches that creaked whenever someone shifted their weight. Some clutched manila folders stuffed with documents. Others stared at their phones, trying to distract themselves from the anxiety of waiting. The air conditioning struggled against the humidity seeping in from outside, making the whole room feel sticky and uncomfortable. Judge Harold Whitman entered through the door behind the bench, his black robe swishing as he climbed the 3 steps to his elevated seat. He was in his mid-50s, with salt and pepper hair combed back from a face that suggested he'd been handsome once but had grown soft around the edges. He carried himself with the casual confidence of a man who'd presided over this courtroom for nearly 15 years. His lips curved into an easy smile as he settled into his leather chair, the kind of smile that said he knew exactly how his day would unfold because every day unfolded the same way. He barely glanced at the file the clerk placed before him. Carter versus County Housing Authority. Property dispute. Failure to comply with eviction order. His eyes skimmed the first few lines before he looked up at Mrs. Carter, sizing her up in an instant. Another confused senior, he thought. Another simple case that would be wrapped up before lunch. All rise. The bailiff called out, though most people were already standing. The formality felt hollow in a room this busy, this routine. Judge Whitman gestured for everyone to sit and immediately called the case. Carter versus County Housing Authority. Is Mrs. Evelyn Carter present? Mrs. Carter rose slowly from her seat, her movements careful and deliberate. Her joints protested quietly as she stood, one hand gripping the edge of the table for balance. Yes, Your Honor. I'm here. Her voice was soft but clear, with the measured cadence of someone who chose her words carefully. She started to continue, to explain the nature of her dispute, but Judge Whitman held up one hand. Ma'am, he said, his tone patronizing in a way that somehow managed to sound almost friendly. Just answer yes or no. We don't need a life story today. A few scattered chuckles rippled through the courtroom. Someone in the back roast snickered. Mrs. Carter paused, her lips pressing together for just a moment before she nodded politely. Yes, Your Honor. The prosecutor, Daniel Rowe, sat at the opposite table with a leather portfolio open in front of him. He was in his early 40s, lean and sharp-featured, with the kind of ambition that showed in the expensive watch on his wrist and the way he leaned back in his chair like he owned the room. When Judge Whitman made his comment, Rowe allowed himself a small, knowing smirk. He caught the eye of one of the clerks and raised his eyebrows slightly, as if to say, this won't take long. Even the court clerk, a young woman named Patricia who'd worked there for 3 years, avoided looking directly at Mrs. Carter. She kept her eyes on her computer screen, her fingers hovering over the keyboard. Patricia felt a twinge of discomfort in her chest, the kind you get when you witness something that doesn't sit right, but don't know what you're supposed to do about it. She told herself that Judge Whitman was just trying to move things along. The docket was packed. They had 30 more cases to get through before 5 o'clock. Judge Whitman leaned back in his chair, the leather creaking under his weight. He glanced at the file again, this time actually reading a few more lines. So let me understand this correctly, Mrs. Carter. You're currently residing in a property that belongs to the county. Is that right? It belonged to my late sister. Your Honor, Mrs. Carter said, her voice steady. The eviction order states that I failed to comply with. Yes or no, please, Judge Whitman interrupted, his smile widening just a fraction. Are you currently living in the property in question? Yes, Your Honor. And you received notice to vacate 60 days ago? Yes, Your Honor. But the circumstances? Yes or no is sufficient, ma'am. Judge Whitman looked out at the courtroom, his expression one of exaggerated patience. You know, we get a lot of folks in here who don't quite understand how modern zoning laws work, especially people of a certain age. No offense intended, of course. More laughter this time, louder and more confident. Someone near the front actually grinned openly. Mrs. Carter stood perfectly still, her hands now clasped in front of her. She didn't flinch. She didn't look away. Her dark eyes remained fixed on Judge Whitman with a calm, almost clinical focus, as if she were studying him rather than being judged by him. A young public defender named Marcus Chun. No, Marcus Bradley, sat at the edge of the defendant's table. He'd been assigned to Mrs. Carter's case that morning, handed the file just 20 minutes before court began. He was fresh out of law school, still idealistic enough to believe that every case mattered, still naive enough to think that speaking up would make a difference. He cleared his throat and half rose from his seat. Your Honor, if I may address the court regarding the circumstances. Judge Whitman waved him down without even looking at him. Counsel, this won't take long. Let's not waste taxpayer money on a case this straightforward. Please sit down. Marcus hesitated, his mouth half open, before slowly lowering himself back into his chair. He felt his face flush with embarrassment and frustration. Beside him, Mrs. Carter placed a gentle hand on his forearm, just for a second, as if to say it's all right. The gesture surprised him. Most defendants in her position would be panicking by now, looking to their lawyer for rescue. Mrs. Carter seemed almost serene. Judge Whitman flipped through another page of the file, squinting at something near the bottom. Now, Mrs. Carter, it says here you filed a motion claiming the eviction order is unlawful. Is that correct? Yes, Your Honor, she said quietly. The order violates several procedural requirements outlined in unlawful. Judge Whitman repeated, emphasizing the word as if tasting it. He looked up at her with raised eyebrows, his smile now taking on a mocking edge. That's quite a big word. Did someone tell you to say that? Did you read it somewhere? The courtroom erupted into laughter, genuine this time. People in the gallery exchanged glances and grinned. Even the bailiff, a stocky man in his 60s who'd seen 1,000 cases just like this one, allowed himself a small smile. Mrs. Carter didn't respond immediately. She simply stood there, her expression unchanged, absorbing the mockery like rain on stone. When the laughter finally died down, she spoke in that same soft, steady voice. Yes, Your Honor. I used that word because it accurately describes the situation. Something about her tone made a few people in the courtroom shift uncomfortably. It wasn't defiance exactly. It wasn't even confidence. It was something else, something harder to define. It was the tone of someone who knew precisely what she was saying and why. In the back row of the gallery, a law student named David Harrison sat with a notebook open on his lap. He was 24, in his second year at the state university, and he'd come to observe real courtroom proceedings for a class assignment. He'd been watching Mrs. Carter since she first stood up, and something about her bothered him. Not in a bad way, more like a puzzle piece that didn't quite fit. She wasn't nervous. That was the first thing. Most defendants, especially elderly ones facing housing disputes, came into court scared and overwhelmed. They stammered. They apologized too much. They looked at their lawyers like drowning people looking at lifeguards. Mrs. Carter did none of those things. She stood perfectly still, her posture straight despite her age. And her eyes, David couldn't stop noticing her eyes. She wasn't looking at Judge Whitman the way defendants usually did. She was studying him, watching him the way a teacher watches a student taking a test. Judge Whitman checked his watch, a clear signal that he wanted to move things along. All right, Mrs. Carter, here's what's going to happen. I'm going to schedule a summary ruling for later this afternoon. That gives you a few hours to think about whether you want to continue contesting this, or whether you'd prefer to simply comply with the county's order and avoid any additional penalties. He paused, letting the words sink in. Because I'll be honest with you, ma'am. If we proceed with this hearing and I rule against you, which seems very likely, I may have to impose fines. Substantial finis. Sometimes people need to learn lessons the hard way. The threat hung in the air, obvious and heavy. Mrs. Carter nodded once, slowly. I understand, Your Honor. Thank you for your time. You're welcome, Judge Whitman said, his tone magnanimous now, as if he'd just done her a tremendous favor. He reached for his gavel. We'll reconvene at 2 o'clock sharp. Please don't be late. He brought the gavel down with a sharp crack, and the bailiff called for everyone to rise. As Judge Whitman stood and turned toward his chambers, he leaned slightly toward Daniel Rowe, the prosecutor. His voice carried just far enough for those nearby to hear. This is why people should know their place. Rowe laughed quietly, gathering his papers. Makes our job easier when they don't. Mrs. Carter stood motionless for a moment, her hands still folded in front of her. Then she reached for her worn brown coat, which she'd draped over the back of her chair, and pulled it on slowly. Her fingers worked the buttons with practiced ease, and when she was done, she picked up a small, weathered purse from the table. She didn't look angry. She didn't look defeated. If anything, her eyes seemed sharper now, more focused, like someone who'd just confirmed something they'd suspected all along. Marcus Bradley, the young public defender, touched her elbow gently as the courtroom began to empty. Mrs. Carter, I'm so sorry. That was completely inappropriate. If you want, I can file a formal complaint about the judge's conduct. She turned to him with a kind smile, the sort of smile that made him feel both comforted and oddly young. That's very thoughtful of you, Mr. Bradley. But it's not necessary. Not yet. Are you sure? Because what just happened in there, that wasn't justice. That was. I know what it was, she said softly, patting his hand. And I appreciate your concern. Truly. But sometimes things need to unfold exactly as they're meant to. Marcus frowned, confused by her phrasing. But before he could ask what she meant, Mrs. Carter had already turned and begun walking toward the exit. She moved slowly, careful on the polished floors, just another elderly woman making her way through a system that had no time for her. Outside the courtroom, the hallway was packed with people waiting for their own cases to be called. Lawyers huddled with clients in corners. Parents tried to keep restless children quiet. The smell of burnt coffee drifted from a vending machine near the elevators. Mrs. Carter made her way through the crowd until she found a wooden bench near a tall window that overlooked the rain-soaked parking lot. She sat down carefully, arranging her coat around her, and then simply waited. The rain continued its steady drumming against the glass. Water streaked down in irregular patterns, distorting the view outside. Mrs. Carter watched the rain for a long time, her face unreadable. But inside her mind, memories stirred like sediment at the bottom of a lake. She saw herself decades younger, standing at a very different bench. This one was grander, made of dark mahogany that gleamed under carefully arranged lighting. She wore formal robes, not faded civilian clothes. Her voice carried across a packed chamber where every word was transcribed, every gesture noted. She remembered the weight of responsibility, the knowledge that her decisions would ripple outward, affecting lives she'd never meet. That was a long time ago, she thought, and yet not long enough for some things to change. She'd come to this town deliberately. She'd chosen this courtroom, this judge, this particular Monday morning. It hadn't been random chance that brought her to that defendant's table. She planned it carefully, making inquiries through channels most people didn't even know existed. She'd filed the paperwork herself, using a name that was legally hers but professionally dormant. She dressed in clothes that would make her invisible, forgettable, just another elderly black woman who didn't know better. And she'd watched. She'd seen exactly what she'd expected to see. Footsteps echoed down the hallway, the rhythmic squeak of rubber soles on linoleum. A courthouse janitor pushed a wide mop bucket toward the elevators, his movements automatic, practiced. He was in his 60s, thin and weathered, with gray stubble on his jaw and kind eyes that had seen too much for too long. As he passed Mrs. Carter's bench, he paused. Something about her profile caught his attention. He stared for a moment, his eyes widening slightly. "Ma'am?" he whispered, his voice barely audible over the hallway noise. Mrs. Carter turned her head and met his gaze. For just a second, something passed between them, a recognition that went beyond names or faces. She gave him the gentlest of smiles and shook her head almost imperceptibly. "Not yet." The janitor swallowed hard, nodded once, and continued down the hall with his mop bucket. His hands trembled slightly as he gripped the handle. Meanwhile, 3 floors up, Judge Harold Whitman sat in his private chambers with his robe hanging on a hook by the door. He'd loosened his tie and poured himself a cup of coffee from the personal machine on his credenza. Daniel Rowe, the prosecutor, lounged in one of the leather chairs across from the desk, one ankle crossed over his knee. "That was almost too easy," Rowe said, shaking his head with amusement. "I thought she might put up more of a fight." Whitman waved a hand dismissively. "They never do. You get these elderly folks in here, especially the ones without money for real lawyers, and they just don't understand how the system works. They think they can stand up and tell their story, and somehow that's going to change everything." He took a sip of his coffee. "It's almost sad, really." "Almost," Rowe agreed. "So what are you thinking for the afternoon ruling? Standard fines?" "I'm thinking we push a little harder," Whitman said, leaning back in his chair. "Make an example. We've got too many people in this county who think they can just ignore eviction orders and waste the court's time with baseless motions. If we hit her with significant penalties, word gets around. Makes our jobs easier down the line." Rowe nodded slowly, considering. "I can work with that. I'll have the paperwork ready by 1:30. They talked for a few more minutes about other cases on the docket, about procedural matters and scheduling conflicts. Neither of them gave Mrs. Carter another thought. She'd already been filed away in their minds as resolved, finished, one more tedious obligation checked off the list. Back on the first floor, Marcus Bradley caught up with Mrs. Carter at her bench. He carried her case file under one arm and looked genuinely distressed. "Mrs. Carter, I need to apologize again for what happened in there. Judge Whitman's behavior was completely out of line. I should have objected more forcefully." "You did your best, Mr. Bradley," she said kindly. "Please don't blame yourself." "But it's not right," he insisted, sitting down beside her without asking permission. His youth showed in his earnestness, in the way he still believed that pointing out injustice might somehow fix it. "The way he spoke to you, the way he dismissed your concerns without even hearing the substance of your argument, that's not how the system is supposed to work." Mrs. Carter studied him for a moment, her head tilted slightly. "Tell me something, Mr. Bradley. Is this courtroom always this, relaxed about procedure?" The question surprised him. "What do you mean?" "I mean exactly what I said. Does Judge Whitman typically interrupt defendants? Does he routinely make jokes at the expense of the people who come before him? Does he rush through cases without proper examination of the facts?" Marcus shifted uncomfortably. "I mean, he's informal, yeah. Some judges are like that. They think it makes the court less intimidating for regular people." "Does it?" she asked. "Make it less intimidating?" He opened his mouth, then closed it. When he finally spoke, his voice was quieter. "No, it makes it worse, actually, because you can't fight back against someone who's mocking you. If he were just cold and professional, at least you'd know where you stood." "Exactly," Mrs. Carter said softly. She reached into her purse and pulled out a small pad of paper and a pen. "Mr. Bradley, I have a favor to ask. I need copies of the court transcript from this morning. The complete transcript, including every word spoken and every interruption. I also need the docket numbers for Judge Whitman's rulings over the past 6 months, particularly in housing disputes." Marcus blinked, caught off guard by the specificity of the request. That's pretty unusual. Can I ask why? You can ask, she said with a small smile. But I'm not quite ready to explain. Let's just say I like to be thorough in my documentation. Something about the way she said documentation made Marcus pause. It wasn't the word itself, but the precision behind it, the sense that she was operating on a level he didn't quite understand yet. Okay, he said slowly. I can get those for you. It might take a couple of hours. That's perfectly fine. We have until 2 o'clock. Marcus stood, still holding the file, still looking uncertain. Mrs. Carter, can I ask you something? Of course. You don't seem scared. Most people in your position would be terrified right now. But you're not. Why? She looked up at him, and for just a moment he saw something in her eyes that made him take an involuntary step back. It wasn't anger or fear. It was something closer to certainty, the kind of certainty that comes from knowing exactly how a story ends because you've read it before. Because, Mr. Bradley, she said quietly, I know something Judge Whitman doesn't. What's that? That justice doesn't require his permission. Marcus left to gather the documents she'd requested, his mind churning with questions he didn't know how to ask. Mrs. Carter returned her attention to the rain. An hour passed. People came and went through the courthouse. Cases were called and resolved. The world continued turning, indifferent to the small dramas playing out in its courtrooms. Patricia, the court clerk, came down during her lunch break to get something from the vending machine. She noticed Mrs. Carter still sitting on the bench and felt that same uncomfortable twinge again. On impulse, she walked over. Ma'am, are you all right? Do you need anything? Mrs. Carter looked up, surprised by the kindness. I'm fine, thank you. Just waiting for this afternoon's session. Patricia hesitated, then lowered her voice. Look, I probably shouldn't say this, but Judge Whitman can be difficult. If you're thinking about representing yourself this afternoon, you might want to reconsider. Maybe ask for a continuance, get a better lawyer, someone with more experience. That's very thoughtful of you, Mrs. Carter said. But I think I'll be fine. Patricia wanted to say more, to ward her somehow, but she didn't know how to put it into words without crossing a professional line she couldn't afford to cross. So she just nodded and walked away, feeling like she should have done more, but not knowing what more she could do. When Marcus returned 90 minutes later, he carried a thick folder containing the transcript and a printed list of docket numbers. He sat down beside Mrs. Carter and spread the papers on the bench between them. Here's everything you asked for, he said. And Mrs. Carter, I have to tell you, looking through some of these other cases, there's a pattern. Judge Whitman tends to rule harshly in housing disputes, especially when the defendant is low income or elderly. A lot of his rulings have been appealed, but most people can't afford to appeal, so they just accept whatever he decides. Mrs. Carter read through the transcript carefully, her finger tracing each line. When she reached the section where Judge Whitman had mocked her use of the word unlawful, she paused. Mr. Bradley, this citation here. When the judge dismissed your objection, he claimed time constraints, but he didn't follow proper procedure for summary dismissal. You need to establish lack of material dispute first. Marcus stared at her. How do you know that? She looked up from the page. I read. No, I mean, that's a pretty specific procedural point. Most people wouldn't catch that. Hell, most lawyers wouldn't catch that. Mrs. Carter folded the transcript neatly and placed it in her purse. Sometimes experience teaches you to notice things others miss. David Harrison, the law student who'd been watching earlier, happened to be walking past on his way to observe another courtroom. He recognized Mrs. Carter from the morning session, and something made him stop. He'd been thinking about her case all through lunch, about the strange calm she'd displayed, about the way she'd spoken. It nagged at him. He approached cautiously. Excuse me, ma'am. I was in the courtroom this morning. I'm a law student, and I just wanted to say that what happened to you wasn't right. Thank you, Mrs. Carter said. That's kind of you to say. David hesitated, then pulled out his phone. I hope this doesn't sound strange, but I was trying to look you up. Evelyn Carter, right? I want to see if you had any prior cases in the system, maybe something that could help your defense. But I couldn't find anything. No other cases, no property records under that name in this county. It's like you don't exist. Mrs. Carter smiled, a real smile this time. Perhaps I don't. Not here, anyway. The cryptic answer should have frustrated him, but instead it only deepened his curiosity. He stood there for another moment, wanting to ask more questions, but something in her expression told him he wouldn't get answers. Not yet. Mrs. Carter's phone buzzed quietly in her purse. She pulled it out, an old flip phone that looked like it belonged to a different decade. She answered without checking the caller ID. Yes, she said simply. A voice spoke on the other end, too quiet for anyone nearby to hear. Yes, I'm certain, Mrs. Carter replied. Let it proceed. She closed the phone and tucked it back into her purse. When she looked up, she noticed that the rain had finally stopped. Pale sunlight was trying to break through the clouds, casting strange shadows across the parking lot. The afternoon session would begin in less than 30 minutes. Mrs. Carter stood slowly, smoothing her coat, adjusting her purse strap. She looked at Marcus, who'd been sitting beside her in confused silence. Mr. Bradley, when we go back in there, I need you to trust me. Can you do that? Ah, yes. Of course. Good. Because things are going to happen quickly, and I need you to stay calm no matter what you hear. Mrs. Carter, what are you planning? She patted his shoulder gently. I'm planning to let Judge Whitman finish what he started. They made their way back to the courtroom, joining the stream of people filing through the double doors. The afternoon light slanted through the high windows differently now, making the room feel both familiar and strange. Mrs. Carter took her seat at the defendant's table. Marcus sat beside her, his knee bouncing with nervous energy. Daniel Rowe, the prosecutor, was already at his table, looking relaxed and confident. Judge Whitman entered exactly at 2 o'clock, his robe freshly pressed, his expression businesslike. He'd had a good lunch and a strong coffee, and he was ready to clear the remaining cases quickly so he could leave by 4:30. He barely glanced at Mrs. Carter as he took his seat, but as he raised his eyes from the bench to call the session to order, he happened to catch her gaze. She was looking directly at him, her expression calm and patient, with that same unblinking focus she'd had all morning. Something about it made him pause, just for a fraction of a second. It was the look of someone who knew something he didn't, someone who was waiting for him to catch up. For the first time that day, Judge Harold Whitman felt the smallest flicker of uncertainty. And in that moment, Mrs. Evelyn Carter knew the trap was ready to spring. Judge Whitman's moment of uncertainty passed as quickly as it came. He shook it off, straightened his chair, and banged his gavel once to bring the afternoon session to order. The courtroom settled into attentive silence, though it was the lazy kind of attention people give to proceedings they expect to be brief and predictable. We're here to conclude the matter of Carter versus County Housing Authority, Judge Whitman announced, his voice carrying that familiar tone of casual authority. Mrs. Carter, you've had several hours to consider your position. Have you decided to comply with the county's eviction order, or are we proceeding with a formal ruling? Mrs. Carter stood slowly, her hands resting on the table for balance. We're proceeding, Your Honor. Judge Whitman's eyebrows rose slightly, as if surprised she'd chosen to waste everyone's time. Very well, then let's make this quick. He gestured toward Daniel Rowe. Counselor, present your case. Rowe stood, buttoning his suit jacket with practiced ease. He moved to the center of the courtroom like an actor taking his mark, confident and smooth. Your Honor, this is a straightforward matter. The defendant, Mrs. Evelyn Carter, has been residing in county property for 4 months following the death of her sister, Margaret Carter. The property in question was seized by the county due to outstanding tax liens predating Mrs. Margaret Carter's death. Mrs. Evelyn Carter was served proper notice to vacate 60 days ago and has refused to comply. He placed a stack of papers on the clerk's desk. I'm submitting documentation showing the legal seizure, the notification of eviction, and proof of Mrs. Carter's continued occupancy despite the order. Judge Whitman nodded, flipping through the papers without really reading them. And has the defendant responded to these documents? She filed a motion claiming procedural irregularities, Your Honor. But as you can see from the evidence, all proper channels were followed. This is simply a case of someone refusing to accept a legal decision they don't like. Mrs. Carter remained standing, her expression unchanged. She watched Roe the way someone might watch a play they'd already seen, knowing exactly when each line would be delivered. Marcus Bradley started to stand, but Mrs. Carter placed a gentle hand on his arm. "Not yet," she whispered. Judge Whitman leaned back in his chair. "Mrs. Carter, do you have anything to say in response to the prosecutor's presentation?" "May I ask a question first, Your Honor?" "Keep it brief." Mrs. Carter picked up a single sheet of paper from the table, holding it carefully. Mr. Rowe mentioned that all proper channels were followed. Could he clarify which statute governed the seizure of my sister's property? Rowe barely hesitated. State Code Section 4211, Your Honor. Standard tax lien procedure. Mrs. Carter nodded slowly. "And was notice provided to all potential heirs and interested parties as required under that statute?" "Of course," Rowe said, his tone suggesting the question was beneath him. "May I enter a clarification for the record?" Judge Whitman sighed, but waved his hand in a gesture that said go ahead, though his expression clearly communicated his impatience. Mrs. Carter's voice remained soft, but something in it had changed. The words came with surgical precision. Section 4211, subsection D requires that notice be provided to all living relatives within 30 days of the lien filing. My sister had 3 children, Your Honor. All 3 were alive at the time of the seizure. None of them received notice. That's not a procedural irregularity. That's a constitutional violation. The courtroom went very quiet. Even the usual rustling of papers and shifting of bodies stopped. Marcus Bradley's head snapped toward Mrs. Carter, his eyes wide. Rose's confident smile flickered. "Your Honor, we followed standard protocol." "Standard protocol requires constitutional compliance," Mrs. Carter interrupted gently. "Due process isn't optional, Mr. Rowe. It's foundational." Judge Whitman's jaw tightened. He wasn't used to being corrected, especially not by elderly defendants in worn coats. "Mrs. Carter, I'll remind you that this is my courtroom, and you will not interrupt the prosecutor." "I apologize, Your Honor. I was simply clarifying a point of law." "You're not here to clarify law," Whitman snapped, his patience evaporating. "You're here because you broke the law. There's a difference, and I'd appreciate it if you'd remember that." "I'll note your admonishment for the record," Mrs. Carter said evenly. Something about her phrasing sent a small shiver through the room. "Note it for the record." The language was too precise, too careful. It was the kind of language lawyers used when they were building a case, documenting everything for later review. Judge Whitman's face flushed slightly. "Mrs. Carter, I'm warning you. If you continue this disrespectful attitude toward this court, I'll hold you in contempt. Do you understand?" "I understand, Your Honor. And I would like to formally object to the characterization of constitutional concerns as disrespectful. That objection should also be noted for the record, as is my right under the Sixth Amendment." Marcus Bradley felt his heart hammering in his chest. He'd studied constitutional law. He knew the language Mrs. Carter was using. It was textbook perfect. More than perfect, it was the kind of language that appeared in Supreme Court opinions, not county courtrooms. David Harrison, the law student, had returned to the gallery for the afternoon session. He sat forward now, his notebook forgotten in his lap. Something was happening, something he couldn't quite name yet, but he felt it building like pressure before a storm. Judge Whitman's hands gripped the edge of the bench. "Your objection is noted. Now, do you have any actual evidence to present, or are we finished here?" Mrs. Carter reached into her purse and pulled out a small stack of papers, neatly organized and clipped together. "I do have evidence, Your Honor. I have the original lien filing, which shows the date of seizure. I have birth certificates for my sister's 3 children. And I have postal records showing that no certified mail was sent to any of their addresses during the required notification period." She handed the papers to Marcus, who stood and brought them to the clerk's desk. His hands were shaking slightly. Patricia, the clerk, took the documents and glanced at them. Her face went pale. Rose stepped forward quickly. "Your Honor, we were not provided advance notice of this evidence. Neither were my sister's children provided notice of the seizure," Mrs. Carter said quietly. "That's rather the point, Mr. Rowe." Judge Whitman snatched the papers from the clerk and scanned them, his eyes moving faster and faster across the pages. The flush in his face deepened from pink to red. He could see immediately what Mrs. Carter had documented. The dates didn't match. The required notices weren't there. The entire seizure was built on a foundation that wouldn't survive appeal. But this was a county courtroom, not an appellate court. And Judge Harold Whitman had been ruling his courtroom his own way for 15 years. He wasn't about to let some elderly woman embarrass him in front of a packed gallery. "This doesn't change anything," he said, his voice harder now, stripped of its earlier casual arrogance. "The seizure may have had procedural issues, but you still refuse to comply with a lawful eviction order. That's contempt of court, Mrs. Carter, and I don't take kindly to contempt." "Then please note my objection to that characterization as well," Mrs. Carter said. "An order based on an unconstitutional seizure cannot itself be lawful. I cannot be in contempt of an invalid order." Judge Whitman's face was now fully red. "You're splitting hairs, ma'am." "No, Your Honor. I'm citing constitutional law. There's a significant difference." The judge's hand hovered over his gavel. He wanted to bring it down, to end this, to restore his authority before it slipped any further. But something held him back. That same flicker of uncertainty he'd felt earlier now bloomed into something closer to genuine concern. This woman was too calm, too prepared, too precise in her language. Nothing about her behavior matched what he'd expected. "I'm issuing my ruling," he announced abruptly. "Mrs. Carter, I find you in violation of the eviction order. I'm imposing a fine of $5,000, payable within 30 days. Additionally, you are ordered to vacate the property within 72 hours. Failure to comply will result in arrest for contempt of court. Do you understand?" The courtroom buzzed with whispered reactions. $5,000 was an enormous fine for a housing dispute, especially one involving an elderly woman who clearly had limited means. Marcus Bradley shot to his feet. "Your Honor, that's excessive by any standard." "Sit down, Counselor," Judge Whitman barked. "But Your Honor." "I said sit down." Marcus remained standing for another second, his face flushed with anger and helplessness, before slowly lowering himself back into his chair. He looked at Mrs. Carter, expecting to see defeat or fear. Instead, her expression remained eerily calm, almost expectant. Judge Whitman reached for his gavel, ready to bring it down and end this humiliating afternoon. His fingers closed around the wooden handle. "Your Honor," Mrs. Carter said, her voice cutting through the tension like a bell through fog. "Before you conclude these proceedings, may I state my full legal name for the record?" The judge paused, his hand frozen in midair. The request was odd, but not technically improper. Court records required full legal names. He assumed she'd been using a nickname or shortened version. It was a small thing, barely worth acknowledging, but something in her tone made him hesitate. He sighed, lowering the gavel. "Fine, if it's that important to you, go ahead." Mrs. Carter stood very slowly. The movement seemed to take longer than it should, as if she were rising not just from a chair but from some deeper place. She straightened her back, and suddenly she seemed taller. Her shoulders squared. The worn brown coat no longer looked shabby. It looked like armor she'd chosen deliberately. When she spoke, her voice carried across the courtroom with a clarity and authority that hadn't been there before. Or perhaps it had always been there, hidden beneath a veneer of elderly vulnerability. "My full legal name," she said, each word precise and weighted, "is Evelyn Margaret Carter Hamilton." A few attorneys in the gallery shifted in their seats. One of them, a woman in her 50s who'd practiced law for 30 years, felt her stomach drop. That name. She knew that name. Judge Whitman frowned, looking down at the docket. "That's not what. Carter is my maiden name, Your Honor. I've used it for personal matters since my husband's death. But my legal name, the name I've practiced under for 43 years, is Hamilton." Another attorney in the back row gasped softly. The woman beside him grabbed his arm, her grip tight. "Mrs. Carter, Mrs. Hamilton," continued in that same clear, unwavering voice. "And for the record, I currently serve as an Associate Justice of the United States Supreme Court." The silence that followed was absolute. It was the kind of silence that happens when the world stops making sense for a moment, when reality needs to recalibrate itself around new information that shouldn't be possible but somehow is. Judge Whitman's mouth opened slightly. No sound came out. His eyes went from Mrs. Hamilton to the docket in front of him, then back to her face, as if by looking hard enough he could make her words retroactively untrue. Daniel Rowe, the prosecutor, had been gathering his papers to leave. His hands froze mid-motion. The expensive pen he'd been holding clattered onto the table, the sound absurdly loud in the silence. Patricia, the court clerk, brought both hands to her mouth. Her computer screen blurred in front of her as tears welled in her eyes, though she couldn't have said if they were from shock or horror at what she'd just witnessed. Marcus Bradley sat completely still, his brain working frantically to process what he'd just heard. Supreme Court Justice. The words bounced around in his head, but wouldn't settle into meaning. He'd been assigned to defend a Supreme Court Justice. A Supreme Court Justice he'd watched get mocked and dismissed and threatened all morning. In the gallery, David Harrison felt his entire body go cold. He'd been right. Something had been wrong about her from the start. But this was beyond anything he could have imagined. Judge Whitman finally found his voice, though it came out strangled and uncertain. That's not possible. You can't be. I assure you, Your Honor, I am. Justice Hamilton reached into her purse and pulled out a slim wallet. She extracted a card and held it up. Even from a distance, people could see the seal of the Supreme Court embossed on its surface. Would you like to verify my credentials? Judge Whitman stared at the card like it was a snake. He made no move to take it. Justice Hamilton lowered the card and continued, her voice still gentle, but now carrying unmistakable authority. I took my oath of office 22 years ago. Perhaps you remember it, Judge Whitman. It's the same oath you took when you became a judge. She paused, and then recited from memory, her voice taking on a formal cadence. I do solemnly swear that I will administer justice without respect to persons, and do equal right to the poor and to the rich, and that I will faithfully and impartially discharge and perform all the duties incumbent upon me under the Constitution and laws of the United States. The words hung in the air like an accusation, because everyone in that courtroom had just spent the entire day watching Judge Whitman do exactly the opposite of what those words required. Someone in the gallery started crying. Quiet, muffled sobs that they tried to suppress, but couldn't quite manage. Judge Whitman's face had gone from red to white. His hands trembled slightly as he gripped the bench. Why? He finally managed to ask. Why would you? Because I wanted to observe how justice is practiced at the lowest levels of our legal system, Justice Hamilton said simply. Not in appellate courts, where everyone knows they're being watched. Not in federal courts, where standards are rigidly enforced. But here, in county courtrooms, where most Americans encounter the legal system, where constitutional rights should be most carefully protected, because the people who come here often have no other recourse. She paused, letting the words sink in. I wanted to see if the promises we make in the highest court in the land actually reach the people who need them most. And I wanted to see what happens when someone with power believes they're dealing with someone who has none. Judge Whitman opened his mouth, closed it, opened it again. You can't. There are proper channels for judicial review. Yes, there are, Justice Hamilton agreed. And they'll be followed. But proper channels begin with proper documentation. She gestured toward the court reporter, a young man who'd been transcribing everything with increasingly shaky hands. That transcript is now part of the official record. Every word spoken in this courtroom today, every interruption, every dismissal, every threat, every casual exercise of power against someone you believed was powerless. All of it documented, time-stamped, and preserved. Rowe found his voice, though it came out hoarse. Your Honor, she entrapped. I entrapped no one, Mr. Rowe, Justice Hamilton said, turning her calm gaze on him. I filed a legitimate case involving a legitimate constitutional violation. I followed every proper procedure. I made no false statements. I simply declined to announce my professional credentials and allowed this court to proceed exactly as it would have with any other elderly black woman in my circumstances. She tilted her head slightly. The question isn't what I did. The question is what you did when you thought you could get away with it. The prosecutor sat down heavily, his face gray. Justice Hamilton turned back to Judge Whitman. Now, I have a question for you, Your Honor. Would you like this transcript reviewed exactly as it stands? Every procedural violation, every denial of due process, every moment where you prioritize convenience over constitutional rights. Would you like all of that examined by the Judicial Review Board? Judge Whitman couldn't speak. He physically couldn't form words. His career, his reputation, everything he'd built over 15 years was disintegrating in front of him, and there was nothing he could do to stop it. Justice Hamilton's voice softened slightly, though it lost none of its steel. Or would you prefer to begin making very different choices, starting right now? The judge's hand moved toward his gavel, then away, then back. He looked like a man drowning, grasping for anything that might save him. But there was nothing to grasp. The trap hadn't been sprung today. It had been set weeks ago, every piece carefully positioned, every element documented. She'd given him every opportunity to choose dignity, to choose justice, to choose the principles he'd sworn to uphold. And he'd chosen cruelty instead. The gallery erupted suddenly, no longer able to contain their reactions. People were standing, talking in rushed whispers, pulling out phones. Marcus Bradley sat with his head in his hands, overwhelmed by the magnitude of what had just happened. Patricia, the clerk, was openly crying now, whether from shame or relief that someone had finally stopped this, finally said what needed to be said. Justice Hamilton remained standing, her hands folded in front of her, patient and still. She'd made her statement. Now she would wait to see what came next. Judge Whitman finally looked up at her, and in his eyes was the terrible recognition of complete and total defeat. He'd laughed at her. He'd mocked her. He'd dismissed her concerns and threatened her with fines she couldn't afford. He'd done all of this while she sat quietly, absorbing every word, documenting every violation, building a case that he'd written himself with his own arrogance and casual cruelty. He started but couldn't finish. Justice Hamilton sat back down slowly, arranged her coat around her shoulders, and folded her hands on the table in front of her. When she spoke, her voice was barely above a whisper, but it carried to every corner of the courtroom. Please, Your Honor, proceed. But the gavel never came down, because Judge Harold Whitman knew, in that moment, that there was no way to proceed. There was no ruling he could make, no procedure he could follow, no maneuver he could attempt that would undo what had just been revealed. The system he'd manipulated for 15 years had just looked him in the eye and asked him to explain himself. And he had no answer that wouldn't destroy him. Outside the courtroom, in the hallway, phones were already buzzing. Texts were being sent. News alerts were being drafted. Within the hour, the story would spread beyond the courthouse, beyond the county, beyond the state. By evening, it would be national news. By morning, it would be international. But inside that courtroom, time seemed to have stopped entirely. Justice Evelyn Hamilton sat quietly at the defendant's table, the same place she'd sat all morning, waiting for a system to remember what it was supposed to be. And Judge Harold Whitman sat frozen on his bench, finally understanding that he'd never been judging her at all. She'd been judging him. The silence stretched on, heavy and absolute, broken only by the sound of the court reporter's fingers still typing, still documenting, still preserving every terrible, transformative second for history. Someone in the back row started applauding. Just one person at first, slow and deliberate. Then another. Then another. Within seconds, half the gallery was on their feet, clapping not just for Justice Hamilton, but for something larger, for the moment when power met accountability and couldn't look away. Judge Whitman's gavel remained on the bench, and used and unusable, a symbol of authority that had just learned its own limits. And Justice Hamilton, still wearing her worn brown coat, still carrying her weathered purse, sat quietly and waited for the system to decide who it wanted to be. The applause faded slowly, replaced by a buzzing tension that filled every corner of the courtroom. Judge Whitman sat frozen at the bench, his hands pressed flat against the polished wood as if trying to steady himself against an earthquake only he could feel. The silence that followed wasn't peaceful. It was the kind of silence that comes before something breaks completely. Justice Hamilton remained seated, her posture unchanged. She wasn't gloating. She wasn't even particularly satisfied. She simply sat there, patient and still, like someone who'd completed a difficult but necessary task and was now waiting for others to catch up. The moment stretched on. 60 seconds. 90. People in the gallery shifted uncomfortably, unsure whether they were allowed to leave, afraid to be the first to move. The court reporter's fingers had stopped typing. He stared at his screen, reading back the last few lines he'd transcribed, as if trying to convince himself they were real. Finally, Justice Hamilton spoke. Her voice was quiet but carried perfectly in the expectant hush. Your Honor, I'd like to request that these proceedings be formally paused and that the complete transcript be sealed exactly as recorded. No corrections, no amendments, no clarifications. Every word, every interruption, every judicial remark should be preserved in its original form. Judge Whitman's mouth worked silently. He looked like he wanted to object, to argue, to exercise some remnant of the authority he'd wielded so casually just hours before. But the words wouldn't come. Justice Hamilton turned slightly toward Patricia, the court clerk, whose face was still wet with tears. This is not a suggestion, she said gently. This is a formal request under federal judicial review protocols. Do you understand? Patricia nodded frantically, her fingers already moving toward her keyboard. Yes, ma'am. I understand. I'll seal it immediately. Thank you. Justice Hamilton's tone was kind, without a trace of condescension. She understood that Patricia had been trapped in this system too, watching injustice happen but lacking the power to stop it. Judge Whitman finally found his voice, though it came out weak and defensive. This court was never notified of your identity. If you'd known, you would have treated me with the respect and dignity that every human being deserves when they enter a courtroom. Justice Hamilton interrupted, her voice still soft but now edged with something sharper. But the Constitution doesn't require me to announce my credentials to receive that dignity. It guarantees it to every person, regardless of who they are or what they look like or how much power they appear to have. She paused, letting the words settle. The fact that your behavior would have been different if you'd known who I was is precisely the problem, Your Honor. Justice should never depend on whether someone can prove they're important enough to deserve it. Judge Whitman's face flushed again, but this time it wasn't anger. It was shame, raw and undeniable, the kind that comes from seeing yourself clearly for the first time and hating what you find. Justice Hamilton reached into her purse and pulled out a single sheet of paper. She handed it to Marcus Bradley, who still sat beside her in a state of shock paralysis. Mr. Bradley, this is a formal motion to recuse Judge Whitman from this case due to demonstrated bias and failure to uphold constitutional standards. Please file it with the clerk. Marcus took the paper with trembling hands. He glanced at it and felt his breath catch. The motion was perfect. Every citation was correct. Every legal argument airtight. She must have written it before court even began, knowing exactly how this would unfold. Your Honor, Justice Hamilton continued, I'm requesting that you formally recuse yourself, not as a courtesy, as a legal necessity. Judge Whitman looked down at his hands. They were shaking slightly. He could refuse. Technically, he had that power, but everyone in the courtroom knew what would happen if he did. The motion would be appealed. The transcript would be reviewed, and his refusal would become just one more item on a growing list of judicial misconduct. I recuse myself, he said quietly. The words seemed to cost him something essential. His shoulders sagged as he spoke them, as if the weight of his authority had been the only thing holding him upright. Daniel Rowe, the prosecutor, had been sitting motionless at his table, his face drained of color. Now he stood abruptly, his chair scraping loudly against the floor. Your Honor, I need to object to this entire proceeding. Justice Hamilton deliberately concealed her identity, which amounts to what, Mr. Rowe? Justice Hamilton turned her calm gaze on him. To what exactly does it amount? I filed a legitimate case. I presented valid evidence. I followed every required procedure. I made no false statements under oath. The only thing I declined to do was tell you in advance that I had the knowledge and resources to defend myself properly. She tilted her head slightly. Are you suggesting that justice should only be accessible to those who announce their credentials first? Rowe opened his mouth, then closed it. He had no response that wouldn't make things worse. After a long moment, he sat back down, his expensive suit suddenly looking like a costume he no longer knew how to wear. You were never being tested on law, Mr. Rowe, Justice Hamilton said quietly. You were being tested on character. And I'm afraid you've shown us exactly who you are when you think no one important is watching. The prosecutor's hands clenched into fists on the table. He stared straight ahead, unable to meet anyone's eyes. Marcus finally found his voice. What happens now? Justice Hamilton looked at him with something approaching warmth. Now we wait for a visiting magistrate to be assigned. Someone without a stake in protecting this court's reputation. Someone who can evaluate this case on its actual merits. She paused. And then my case will be dismissed, Mr. Bradley, because the eviction order was never valid. It was built on a constitutional violation, and constitutional violations don't become legitimate just because they're convenient. Within 15 minutes, a visiting magistrate named Judge Carol Brennan arrived. She was in her early 60s, with steel gray hair and sharp eyes that took in the tense courtroom with immediate understanding. She'd been briefed on the basics during her drive over, and her expression suggested she wasn't particularly surprised by what she'd been told. I've been asked to assume judicial oversight of this case, Judge Brennan announced, settling into the bench that Judge Whitman had vacated. I've reviewed the preliminary documentation, and frankly, I've never seen anything quite like this situation. She looked directly at Justice Hamilton. Your Honor, I'm not entirely sure of the proper protocol here. Justice Hamilton smiled slightly. The proper protocol is to treat this as you would any other case, Judge Brennan. Evaluate the evidence. Apply the law. Render a fair decision. My position on the Supreme Court is irrelevant to the constitutional merits of this particular dispute. Judge Brennan nodded slowly. Then that's exactly what I'll do. She spent the next 20 minutes reviewing the evidence Justice Hamilton had presented, asking clarifying questions, and examining the documentation that showed the county's failure to notify the required parties. When she finally looked up, her decision was clear in her expression. This eviction order is constitutionally invalid, she announced. The county's seizure of the property failed to meet the due process requirements outlined in State Code Section 4211, subsection D. Without valid seizure, there can be no valid eviction. This case is dismissed with prejudice. Justice Hamilton stood and inclined her head respectfully. Thank you, Judge Brennan. No, Judge Brennan said quietly. Thank you for reminding all of us what we're supposed to be doing here. Before leaving the courtroom, Justice Hamilton turned back to where Judge Whitman still sat in one of the gallery benches, having surrendered his elevated position. She walked over to him slowly, and people nearby held their breath, wondering what she would say. She didn't shout. She didn't lecture. She simply looked at him with something that might have been pity and said one line, soft enough that only those closest could hear. You were never being tested on law, only on character. Then she turned and walked toward the exit, Marcus Bradley hurrying to follow her, still carrying the file that had started all of this. Judge Whitman didn't respond. He couldn't. He just sat there, staring at nothing, while around him the courtroom began to empty and the world he'd known for 15 years crumbled into dust. In the hallway, phones were already buzzing with notifications. Someone had leaked the story. Within minutes, local news alerts began appearing on screens across the county. Within an hour, national outlets picked it up. The headline variations were remarkably consistent. Supreme Court Justice reveals identity after being mocked in county court. Some added, judge's career in jeopardy after humiliating exchange caught on record. By evening, the story had exploded across every major news platform. Video clips circulated online, though they were audio only, since cameras weren't allowed in the courtroom. But the audio was damning enough. Judge Whitman's condescending tone, his jokes about people of a certain age, his casual dismissal of constitutional concerns, all of it preserved in digital amber for the world to hear and judge. Civil rights organizations moved quickly. By the next morning, 3 separate groups had formally requested access to Judge Whitman's past rulings, particularly in cases involving housing disputes, elderly defendants, and low-income communities. The Southern Justice Alliance issued a statement calling for a comprehensive federal ethics review. The National Coalition for Fair Courts announced they would be reaching out to former defendants who'd appeared before Judge Whitman to document patterns of bias. Justice Hamilton, working from a hotel room in the county seat, quietly authorized the federal ethics review. She made a single phone call to the chief judge of the district, explaining what had happened and what she'd observed. The conversation was brief and professional. By the time she hung up, the wheels of judicial oversight were already in motion. The former defendants started coming forward within 48 hours. First a few, then dozens, then more than 100. Their stories were eerily similar, like variations on the same cruel theme. An elderly black man who'd been mocked for not understanding property tax law. A Hispanic woman whose concerns about an unlawful search had been dismissed as time-wasting. A young white mother who'd been told she should have thought about her children before breaking the law, even though the charges against her had been dropped. The pattern was unmistakable. Judge Whitman had been particularly harsh with defendants who appeared poor, uneducated, or otherwise vulnerable. He'd routinely rushed through cases without proper examination of evidence. He'd denied requests for continuances that should have been granted. He'd imposed excessive fines on people who could least afford them. And he'd done all of it with the casual confidence of someone who believed he'd never be held accountable. One woman, a 73-year-old grandmother named Dorothy Fletcher, gave an interview that went viral. She'd appeared before Judge Whitman 2 years earlier over a dispute about yard maintenance. He'd fined her $800 and made jokes about her inability to maintain her property, suggesting she should move to a nursing home. The fine had forced her to choose between medication and groceries for 3 months. "I thought that was just how the system worked," she said on camera, tears streaming down her face. "I thought judges were allowed to talk to you like that. I thought I didn't have any rights because I couldn't afford a real lawyer." But watching what happened to Justice Hamilton made me realize it wasn't about the law. It was about him thinking we didn't matter. Daniel Rowe, the prosecutor, was placed on administrative leave within 72 hours. An internal investigation by the district attorney's office uncovered a disturbing pattern of emails and memos. Rowe had routinely encouraged other prosecutors to seek fast-track penalties for what he called non-compliant types. In one email, he'd written, "Judge Whitman doesn't waste time on sob stories. If you want quick convictions, schedule your cases on his docket." The emails revealed something even more troubling. Rowe had been deliberately steering certain types of cases, particularly those involving poor defendants or housing disputes, to Judge Whitman's courtroom because he knew the judge could be counted on for harsh rulings. It wasn't justice. It was a systematic exploitation of judicial bias. David Harrison, the law student who'd noticed something was wrong from the beginning, found himself in an unexpected spotlight. A national news program contacted him, asking for an interview about what he'd witnessed. He agreed, and the interview aired during prime time. "I almost laughed too," he admitted on camera, his voice thick with shame. "When Judge Whitman made that first joke about not needing a life story, I almost laughed, because it seemed funny in the moment. Just a judge moving things along, keeping control of his courtroom." He paused, struggling with the words. "But that's what scares me most. How easy it was to participate in cruelty without even realizing it. How quickly you can become part of a system that dehumanizes people just by not questioning why everyone else thinks it's normal." The interviewer asked him what he'd learned from the experience. "That silence is complicity," David said simply, "and that the people who look powerless often see things the powerful can't." Justice Hamilton sat there all morning, absorbing mockery and disrespect, and she never stopped paying attention. She was documenting everything, building a case not just against one judge, but against an entire culture of casual cruelty. and I was sitting there taking notes for a class assignment, thinking I was observing justice when I was actually witnessing its absence. The interview clip was shared millions of times. Law schools began assigning it as mandatory viewing. Ethics professors used it to illustrate the difference between legal authority and moral authority. Meanwhile, Justice Hamilton met privately with a judicial oversight panel convened specifically to review the situation. The meeting took place in a conference room in the federal courthouse, far removed from the county court where everything had begun. 6 judges, all senior members of the federal bench, sat across a long table from her. They asked her to walk them through her decision to conduct what one of them called an undercover observation. She explained calmly that this wasn't her first such observation, though it was perhaps the most disturbing. Over the years, she'd visited various courtrooms without announcing her identity, wanting to see how justice actually functioned at the ground level, where most Americans encounter the legal system. "We make grand pronouncements from the Supreme Court," she told them. "We establish precedent and interpret the Constitution. But those interpretations only matter if they're actually applied in county courtrooms and municipal courts. That's where rights are protected or violated. That's where the promise of equal justice becomes either real or hollow." She paused, choosing her words carefully. "I needed to see what happens when judges believe they're dealing with someone who has no power, no voice, no recourse. Because that's when we discover who we truly are as a legal system. Not in the high-profile cases where everyone's watching, but in the routine proceedings where we think no one important is paying attention." One of the panel members, a judge named Morrison, leaned forward. "But don't you think there's something deceptive about concealing your identity? Something that undermines the integrity of the judicial process?" Justice Hamilton met his eyes steadily. "With respect, Judge Morrison, I think what undermines the integrity of the judicial process is judges who treat human beings with contempt because they believe those human beings can't fight back. I didn't lie. I didn't falsify evidence. I simply declined to announce credentials that should never have been necessary for me to receive basic dignity." Judge Morrison nodded slowly, conceding the point. Another panel member asked if she'd observed similar patterns in other courtrooms. "Yes," Justice Hamilton said simply. "Not always this overt, not always this systematic, but the underlying problem is consistent. There's a culture in some courtrooms where efficiency trumps justice, where convenience matters more than constitutional rights, where judges forget that every person who comes before them is someone's mother or father or child, someone who deserves to be heard." The panel thanked her for her time and assured her that their review would be thorough and impartial. She left the federal courthouse through a side entrance, avoiding the reporters who'd gathered out front. Judge Whitman hired a public relations firm within a week. They crafted a statement that described the incident as a misunderstanding and suggested that his comments had been taken out of context. The humor, they claimed, was meant to put nervous defendants at ease, not to belittle them. The quick proceedings were described as an attempt to serve the community efficiently, not as a failure of due process. The public response was brutal and immediate. Social media tore the statement apart line by line. Legal experts appeared on news programs to explain exactly why the PR spin was nonsense. Former defendants posted their own stories, providing context that made the misunderstanding explanation impossible to sustain. Within days, the PR firm quietly withdrew from representing him. They issued no statement, but sources close to the firm suggested that continued association with Judge Whitman had become untenable for their reputation. The deeper investigation into Judge Whitman's history uncovered evidence that was even more damning than the initial incident. Court records showed that he'd routinely altered transcripts in past cases, editing out remarks that might be seen as problematic on appeal. He'd ignored mandatory bias training for 3 consecutive years, filing paperwork that claimed completion without actually attending the sessions. He denied proper due process in dozens of cases, knowing that most defendants lacked the resources to appeal. One particularly disturbing discovery involved a case from 4 years earlier. A homeless veteran had appeared before Judge Whitman on a charge of trespassing. The man had tried to explain that he was sleeping in an abandoned building because the local shelter was full. Judge Whitman had cut him off repeatedly, made jokes about his appearance, and sentenced him to 30 days in jail. The veteran had died of a heart attack while incarcerated. His public defender had tried to file a complaint about the judge's conduct, but had been discouraged by supervisors who said it would hurt his career. That public defender, now working in private practice, came forward with documentation of what had happened. "I knew it was wrong," he said in a written statement, "but I was young and scared and convinced myself that this was just how the system worked. I told myself that fighting would only hurt my clients in the long run because I'd be blacklisted by judges. But watching Justice Hamilton refuse to accept that logic made me realize I'd been making excuses for cowardice." The courthouse janitor, whose name was Samuel Wright, eventually gave his own testimony to the oversight panel. He was 64 years old, a former civil rights activist who participated in sit-ins and voter registration drives in the 1960s. He'd taken the janitor job 15 years earlier, after his small business failed, and had quietly observed hundreds of proceedings in Judge Whitman's courtroom. "I recognized her voice," he told the panel, "not from any specific case, but from recordings of Supreme Court arguments I'd listened to. I follow the law because I believe in justice, even when justice hasn't always believed in me. And when I realized who she was, I understood what she was doing. She was bearing witness. She was documenting what people like me have been saying for decades, that the system treats you differently based on who it thinks you are." He paused, his weathered hands folded on the table in front of him. "I've cleaned that courtroom for 15 years. I've mopped up tears from women who couldn't afford their fines. I've emptied trash cans full of legal papers that defendants couldn't understand. I've watched Judge Whitman laugh about cases during his lunch breaks, making jokes about the people who just stood before him begging for mercy. And I kept quiet because I needed the job, because I had grandchildren to support, because I convinced myself that one janitor couldn't change anything." His voice grew stronger. "But Justice Hamilton showed us that you don't need to be loud to be powerful. You don't need to rage to make change. Sometimes the most revolutionary thing you can do is simply refuse to accept being treated as less than human, and then document everything so carefully, so thoroughly, that the truth becomes undeniable." Federal charges against Judge Whitman were never filed. The bar for criminal prosecution of a sitting judge was extremely high, and while his conduct was appalling, it didn't clearly cross into criminal territory. But the ethics violations were more than sufficient. The Judicial Conduct Commission compiled a report that ran to more than 200 pages, documenting a systematic pattern of bias, procedural violations, and failure to uphold constitutional standards. Judge Whitman resigned before formal impeachment proceedings could begin. His statement was brief and included no apology. He cited stress and workload pressures as factors that had affected his judgment. He made no mention of Justice Hamilton. He made no acknowledgement of the hundreds of people he'd treated with contempt over 15 years. The resignation letter was leaked within hours. Legal analysts noted what it didn't say as much as what it did. There was no acceptance of responsibility, no recognition of harm caused, no indication that he understood why what he'd done was wrong. It was the final act of a man who still didn't comprehend that his position had never given him the right to diminish other human beings. Daniel Rowe accepted a plea deal related to prosecutorial misconduct. In exchange for his testimony about the systematic steering of cases to favor judges, he received a reduced penalty, a 5-year suspension of his law license, and 200 hours of community service. He was required to give a series of talks at law schools about ethical failures in prosecution. The first few were painful to watch, with Rowe clearly going through the motions without genuine understanding. But by the 10th or 11th, something seemed to shift. He started talking not from a script, but from a place of genuine reckoning. "I told myself I was serving justice," he said during one talk at State University. "But really, I was serving my own ambition. I wanted convictions. I wanted a good track record. I wanted to look effective and efficient. And I stopped seeing the people I was prosecuting as human beings with rights and dignity. They became cases to me, numbers. Obstacles between me and a perfect record. He paused, his face drawn. Justice Hamilton didn't trap me. I trapped myself the moment I decided that convenience mattered more than constitutional rights. She just forced me to see what I've been doing all along. Several past convictions were reopened based on the evidence of systematic bias. One case involved a family that had been wrongfully evicted from their home 3 years earlier. The mother, Lisa Morgan, had tried to fight the eviction, arguing that the notices had been improperly served. Judge Whitman had dismissed her concerns and ruled against her in less than 15 minutes. The family had spent the next 3 years moving between temporary housing, their children changing schools multiple times, their stability destroyed. Now, with the bias documented and the procedural violations confirmed, their case was reviewed by a different court. The eviction was overturned. The family was allowed to return to their home, with the county ordered to pay damages for the years of displacement. Lisa Morgan spoke at a press conference after the ruling. We kept saying something was wrong. We kept trying to explain that we hadn't been served properly, that we had rights. But nobody listened. Nobody cared. They just wanted us out of the way. She wiped tears from her face. Justice Hamilton listened. Even when everyone else thought she was just another old lady who didn't understand the law, she listened. And she didn't just fight for herself. She fought for all of us who weren't important enough to matter. The courthouse where it all happened became a symbol. Law professors brought their students there to observe proceedings, pointing out what had changed and what still needed to change. The county implemented sweeping reforms, including mandatory recording of all proceedings, quarterly reviews of judicial conduct, and a new system for handling complaints about judicial bias. A small memorial plaque was installed near the courtroom entrance. It didn't mention Justice Hamilton by name. Instead, it honored the right to be heard. With a simple inscription, justice requires not just laws, but the courage to apply them equally to every person, in every case, every single time. Justice Hamilton returned to Washington quietly, resuming her duties on the Supreme Court without fanfare. She declined interview requests. She issued no public statements beyond her testimony to the oversight panel. She'd done what she came to do, and she had no interest in turning it into a spectacle. But months later, she penned a concurring opinion in a case involving due process rights in housing disputes. The opinion never mentioned what had happened in that county courtroom, but anyone who read it carefully could see the experience woven through every paragraph. She wrote about the importance of procedural protections, about the constitutional requirement that every person receive fair treatment regardless of their circumstances, about the fact that rights mean nothing if they're only available to those who know how to demand them. The opinion ended with a single line that law students would quote for years to come. The Constitution doesn't protect the powerful. It protects everyone else from them. And in courtrooms across the country, judges read those words and wondered, if Justice Hamilton walked into their courtroom tomorrow, dressed in ordinary clothes and using a different name, what would she see? What would the transcript reveal about who they truly were when they thought nobody important was watching? The question hung in the air, unanswered and uncomfortable, exactly as Justice Hamilton intended. The resignation letter arrived at the courthouse on a Tuesday morning, delivered by courier in a plain manila envelope. Judge Harold Whitman hadn't come to the building himself. He'd stopped coming 3 days after the incident, unable to face the whispers that followed him through hallways where he'd once walked with easy confidence. The letter was brief, impersonal, stripped of any emotion beyond a thinly veiled resentment. It cited unmanageable stress and mounting pressure from external forces beyond my control. There was no apology. No acknowledgement of the hundreds of people who'd stood before his bench and been treated as less than human. No recognition that the pressure he faced was simply accountability he'd avoided for 15 years. The chief judge of the county court, Margaret Thornton, read the letter twice in her private office. She was 62, with sharp features and sharper instincts, and she'd known for years that something was wrong in Whitman's courtroom. But knowing and proving were different things, and without concrete evidence, without someone willing to document the pattern, there'd been nothing she could do. Now she held that documentation in her hands, and it was far worse than she'd imagined. She picked up her phone and called the administrative office. Harold Whitman's resignation is accepted effective immediately. Begin the process of reassigning his active cases and notify all parties of record. When she hung up, she sat quietly for a moment, staring at the letter. Then she folded it carefully and placed it in a file that would eventually make its way to the state archives. History would judge Harold Whitman, and history, she thought, would not be kind. The news of his resignation spread quickly, carried by the same channels that had amplified the original story. But this time, there was no satisfaction in it, no sense of victory. The people who'd been harmed by Whitman's conduct didn't celebrate. They felt something more complicated, a mixture of validation and grief, relief, and lingering anger at how long it had taken. Justice Hamilton was in her chambers at the Supreme Court when she heard. An aide brought her the news update on a tablet, unsure whether congratulations or condolences were appropriate. Justice Hamilton read the brief article without expression, then handed the tablet back. "Thank you for letting me know," she said simply. The aide hesitated at the door. "Ma'am, if you don't mind my asking, are you satisfied with the outcome?" Justice Hamilton considered the question. "Satisfaction isn't the goal," she said finally. "Correction is. Judge Whitman's resignation doesn't undo the harm he caused. It simply prevents him from causing more. That's necessary, but it's not the same as justice." Then what would justice look like? Justice would look like every person he mistreated having their day in court. Justice would look like systemic reforms that prevent the next Harold Whitman from thriving in obscurity for 15 years. Justice would look like a legal culture that values dignity as much as efficiency. She paused. His resignation is just the beginning of that work, not the end. 2 days after his resignation, Judge Whitman released a public statement through a lawyer. It was longer than his resignation letter, but somehow said even less. The statement claimed that he'd been unfairly targeted by an orchestrated campaign that had taken his words deliberately out of context. It suggested that Justice Hamilton's methods were ethically questionable and that the entire incident had been blown out of proportion by activist groups with political agendas. The statement ended with what might have been the most revealing line. "I remain proud of my 15 years of service to this community and confident that history will recognize the good work I accomplished." The reaction was immediate and brutal. Legal ethics professors used the statement as a teaching tool, dissecting each sentence to show how someone could technically avoid admitting wrongdoing while demonstrating a complete lack of moral understanding. Newspaper editorials pointed out that the transcript of his conduct wasn't taken out of context. It was the context. One editorial in a major national paper put it simply, "Judge Whitman's statement proves exactly what Justice Hamilton documented. He still doesn't understand that treating people with dignity isn't optional. He still believes his authority gave him license to mock and dismiss those who appear before him. And he still cannot see that the problem wasn't that he was caught. The problem is what he did." Within a week, the statement had done more damage to his reputation than the original incident. It showed that he'd learned nothing, felt nothing, understood nothing. The community that might have offered some measure of sympathy found none to give. Daniel Rowe's journey was different. His plea deal required him to surrender his law license for 5 years and complete 200 hours of community service speaking at law schools about prosecutorial ethics. The first several months were painful to witness. He spoke from prepared remarks, his voice flat and defensive, going through the motions without genuine engagement. But something shifted after a student at a third-tier law school asked him a simple question during a Q&A session. "Do you actually understand what you did wrong? Or are you just here because you have to be?" Rowe had opened his mouth to give his standard response about learning from mistakes and the importance of ethical guidelines. But the words stuck in his throat. He looked at the student, a young black woman in the second row with tired eyes and an expression that said she'd already seen too much of the world's cruelty, and something in him broke open. "No," he said finally. "I don't think I do. Not really. I understand intellectually that I violated ethical standards. I understand that I manipulated the system. But do I actually grasp the human cost of what I did? The way my decisions affected real people's lives?" He paused, his hands trembling slightly. I don't know that I can understand that until I stop trying to protect myself from it. The room went silent. The student who'd asked the question leaned forward, waiting. I was so focused on winning, Rowe continued, his voice raw now, stripped of its usual polish. On building a perfect record, on looking good to my supervisors. And I convinced myself that the people I was prosecuting deserved whatever they got because they'd broken the law. I never asked myself if the law was being applied fairly. I never questioned whether the system I was serving was actually serving justice. He sat down on the edge of the desk at the front of the room, suddenly exhausted. Justice Hamilton didn't just expose Judge Whitman. She exposed all of us who participated in that system, who made it work, who benefited from it. And the worst part is that I still want to defend myself. I still want to explain that I was just doing my job, that I didn't create the system. But that's exactly the problem. I did create it. Every time I steered a case to a judge I knew would be harsh. Every time I pursued the maximum penalty instead of a just one. Every time I treated a defendant as an obstacle instead of a human being. The room remained silent, but it was a different kind of silence now. Students were actually listening, actually thinking, actually grappling with the uncomfortable truth that good intentions weren't enough. After that day, Rowe's talks changed. He stopped reading from prepared remarks and started speaking from a place of genuine reckoning. He told stories about specific cases, specific people whose lives he'd helped destroy through his ambition. He didn't ask for forgiveness. He simply bore witness to what he'd done and let students draw their own conclusions about what it meant. One professor who'd heard 3 of his talks said, I don't know if Daniel Rowe has actually changed, but I know he stopped lying to himself. And that's where change has to start. The systematic review of Judge Whitman's past cases uncovered dozens that warranted reconsideration. The process was slow and bureaucratic, hampered by limited resources and the sheer volume of cases that needed review. But one by one, they were examined. The case of Dorothy Fletcher, the 73-year-old grandmother who'd been fined $800 over yard maintenance, was overturned. The fine was refunded with interest. The county apologized in writing. Dorothy used part of the money to install a ramp on her front porch so she could more easily tend her garden. I'm not angry anymore, she told a local reporter who'd followed up on her story. Anger takes energy I don't have. But I'm glad that someone finally said what we all knew, that we deserve better. That dignity isn't something you have to earn. It's something you're born with. The case of the homeless veteran who died in jail couldn't be overturned because the defendant was gone. But his family received a formal apology from the county and a settlement that acknowledged the constitutional violations in his case. His daughter used the money to establish a small fund that paid for public defenders to spend more time with clients who couldn't afford private attorneys. It won't bring him back, she said at the press conference announcing the fund. But maybe it'll mean the next person gets treated like a human being instead of a problem to be processed. Lisa Morgan's family had already been allowed to return to their home, but the broader implications of their case rippled outward. The county reformed its eviction procedures, implementing mandatory review periods and requiring judges to document specific findings before approving evictions. Housing advocacy groups called it the Hamilton Protocol, and other jurisdictions began adopting similar reforms. Lisa's oldest daughter, who'd been 12 when they were first evicted, was now 15. She wrote an essay for her high school English class about the experience. The essay ended with a line that her teacher submitted to a national writing competition. Justice delayed isn't justice denied if it teaches the system to do better next time. But it shouldn't take a Supreme Court justice to make the system remember that we're human. The essay won second place. Justice Hamilton sent the girl a handwritten note of congratulation that said simply, never forget that your voice matters. Not because of who listens, but because of what you have to say. Judge Whitman himself disappeared from public life. He moved to a different state, to a small town where nobody knew his name or his history. He took a job doing legal consulting for a private firm that specialized in helping businesses navigate regulatory compliance. It was quiet work, technical work, the kind of work that required no human interaction and offered no opportunity for the exercise of power. People who'd known him before said he'd changed, that the arrogance was gone. But others, watching more carefully, said it wasn't that he'd learned humility. It was that he'd lost the platform to exercise his cruelty. The impulse might still be there, buried beneath the surface, waiting for another opportunity that would never come. Years later, someone spotted him sitting in the back row of a county courtroom in his new state, just observing. He came regularly, apparently, always sitting in the same spot, always leaving before the proceedings concluded. A clerk who recognized him asked once why he came. "I'm watching," he said simply. "Watching what?" He didn't answer. He just gathered his coat and left, and the clerk was left wondering whether he was searching for redemption or simply studying a world he no longer belonged to. The courthouse, where everything happened, underwent its transformation gradually. The reforms weren't dramatic or flashy. They were small, procedural, the kind of changes that only matter if you're the one standing at the defendant's table hoping someone will actually listen. All proceedings were now recorded, not just transcribed. Judges were required to complete annual bias training, and completion was verified independently rather than through self-reporting. A new position was created, a court advocate whose job was specifically to help defendants understand their rights and access resources. The position was funded partly by fines collected from attorneys and judges found to have violated ethical standards. The memorial plaque near the courtroom entrance became a gathering place. People waiting for their cases would stand in front of it, reading the inscription about the right to be heard. Some found comfort in it. Others found courage. A few found the words they needed to demand that the system live up to its promises. Marcus Bradley, the young public defender who'd been assigned to Justice Hamilton's case, continued his work with renewed purpose. He'd been offered positions at prestigious law firms, opportunities to make far more money than he'd ever see in public defense. He turned them all down. "I used to think I was fighting a system I couldn't change," he explained to a law student who asked why he stayed. "But Justice Hamilton showed me that the system only seems unchangeable when we accept it as it is. The moment you refuse to accept it, the moment you document its failures and demand better, that's when change becomes possible. I'm not saying I'll revolutionize anything, but I can make sure that every client I represent is treated with dignity. And if enough of us do that consistently and carefully, the system has to respond." He kept a copy of the transcript from Justice Hamilton's case in his office, not framed or displayed, just filed away where he could reference it when he needed reminding of why the work mattered. David Harrison, the law student who'd witnessed the original incident, graduated and took a position with a public interest law firm specializing in civil rights litigation. His first major case involved challenging a county court system in another state where judges routinely imposed excessive fines on low-income defendants. During his opening argument, he cited Justice Hamilton's concurring opinion in the housing dispute case. "The Constitution doesn't protect the powerful," he quoted. "It protects everyone else from them. And if our legal system fails to uphold that principle in every courtroom, for every defendant, in every case, then we've abandoned the very foundation of justice." He won the case. The reforms that followed weren't perfect, but they were progress. Justice Hamilton herself returned to her normal life with characteristic quietness. She heard cases, wrote opinions, engaged in the daily work of the Supreme Court. She rarely spoke about what had happened in that county courtroom, though it informed everything she wrote afterward. Her chambers were modest by Supreme Court standards, filled with books and photographs of her family. On one shelf, almost hidden behind a stack of law reviews, sat a worn brown coat folded carefully. She never wore it again, but she never got rid of it either. It served as a reminder, not of the humiliation she'd endured, but of the clarity it had provided. One afternoon, several months after the incident, her law clerk noticed the coat and asked about it. "Why do you keep it?" the clerk asked. "After everything that happened, wouldn't you rather forget?" Justice Hamilton looked at the coat thoughtfully. "I don't want to forget. Memory is what keeps us honest. That coat reminds me that dignity isn't about position or credentials. It's about recognizing the inherent worth in every person, regardless of how they appear or what power they seem to have." She paused. "Besides, it was my mother's coat originally. She wore it to a courtroom once 50 years ago when she tried to register to vote and was turned away. A judge told her she was wasting everyone's time. She came home that day and cried for hours. The clerk was quiet, understanding now why the coat mattered. She never knew that I wore it to a courtroom and documented what happened when power met accountability. Justice Hamilton continued. But I think she would have appreciated the symmetry. The coat outlasted the judge who dismissed her. It outlasted the system that tried to silence her. And it reminds me that the work of justice spans generations. We're never finished. We're just continuing what others started. 2 years after the incident, Justice Hamilton visited the courthouse where it had all happened. She came quietly, without announcement, on a Tuesday morning when the building was busy with routine proceedings. She sat in the public gallery of a courtroom, not the one where Judge Whitman had presided, but another one down the hall, and watched cases being heard. The judge was a woman in her 40s, patient and thorough. She listened carefully to each defendant, asked clarifying questions, explained procedures in language that people could understand. When a nervous defendant stumbled over his words, she gave him time to collect himself. When another couldn't afford the proposed fine, she worked out a payment plan without judgment or mockery. It wasn't perfect. The system still had flaws, still created injustices, still left too many people behind. But it was better. Measurably, documentably better. After court adjourned, Justice Hamilton approached the bench. The judge recognized her immediately, her eyes going wide. Justice Hamilton, I had no idea you were here. That was intentional, Justice Hamilton said with a small smile. I wanted to see how things worked when nobody knew I was watching. The judge's face flushed slightly. And you're doing exactly what you should be doing. Treating every person who comes before you as someone who deserves dignity and due process. It's not easy work, especially when the docket is packed and the resources are limited. But you're doing it anyway. That matters more than you know. The judge's eyes filled with tears. After what happened here with Judge Whitman, I promised myself I'd never let this courtroom become a place where people felt small or powerless. Every morning, I read that plaque by the entrance, the one about the right to be heard. It reminds me why I'm here. Good, Justice Hamilton said simply. Keep reading it. Keep remembering. And know that every time you make that choice, to be patient, to be fair, to treat someone with dignity when you could just process them through the system, you're honoring not just the law, but the people the law is supposed to serve. She left the courthouse the same way she'd entered, quietly and without fanfare. But the judge sat in her chambers for a long time afterward, thinking about that conversation and what it meant to be part of a system that was slowly, painfully learning to be better. That evening, Justice Hamilton returned to the wooden bench outside the original courtroom, the same bench where she'd sat during the morning recess 2 years earlier. The courthouse was nearly empty now, just a few stragglers finishing paperwork and security guards beginning their evening rounds. A young woman sat at the other end of the bench, clutching a folder full of documents. She looked nervous, her leg bouncing with anxiety. She had a court date scheduled for the next morning, a dispute with her landlord over repair issues. Justice Hamilton watched her for a moment, then spoke gently. First time, the young woman looked up, startled. Is it that obvious? Only because I remember the feeling. Justice Hamilton smiled. What helps is remembering that you have a right to be heard. Not just legally, but fundamentally. The judge works for justice, not the other way around. If you know your facts and you tell the truth, you've done everything you need to do. The young woman nodded, looking slightly less terrified. Did you have a case here? I did, Justice Hamilton said. It worked out. The young woman left after a few more minutes, walking toward the exit with her shoulders a little straighter, her grip on the folder a little more confident. Justice Hamilton remained on the bench, watching the last of the daylight fade through the tall windows. She thought about her mother, about Dorothy Fletcher and Lisa Morgan and all the others who'd been dismissed and diminished by a system that should have protected them. She thought about the long arc of justice, how it bent not through dramatic gestures, but through countless small acts of courage and conscience. She stood slowly, careful of her joints, and put on her coat. Not the brown one, that one stayed in her chambers now, but a newer one that fit better and kept out the cold. She walked toward the exit, past the memorial plaque with its quiet promise, past courtrooms where tomorrow's cases would be heard. As she pushed through the heavy doors and stepped into the cool evening air, she thought about the question that judges across the country were now asking themselves. What would the transcript reveal about who they truly were? The answer, she knew, wasn't found in grand pronouncements or perfect decisions. It was found in the daily choice to see every person as deserving of dignity, to listen when it was easier to dismiss, to question when it was simpler to accept, to care when indifference would be more comfortable. Justice didn't announce itself. It didn't arrive in dramatic moments or decisive victories. It accumulated through small decisions, made consistently by people who understood that their power was meant to serve something larger than themselves. Justice Hamilton walked to her car, got in, and drove back toward Washington. The courthouse behind her was just a building, old brick and tall windows and floors that creaked under the weight of history. But inside its walls, something essential was being protected, not perfectly, not always, but more often than before. The right to be heard, the promise of dignity, the possibility that systems could learn, could change, could become what they were always supposed to be. It wasn't the ending of a story. It was the continuation of one that had no ending, only chapters written by each generation's determination to do better than the last. And in courtrooms across the country, judges looked at the people standing before them and made their choices, knowing now that justice was always watching, not to trap them, but to see if they'd remember why they'd taken their oath in the first place. Some remembered, some forgot, but every day, a few more chose to remember. And slowly, imperceptibly, the system bent a little closer toward what it promised to be. When you have power over others, who do you become when you think nobody important is watching? If this story made you think, hit that like button and subscribe for more stories that challenge us to be better.